الرحمن الرحيم. بسم الله وعلى بركة الله نستأنف جلسات هذا اليوم. في هذه المرحلة وصلنا إلى الجلسة الأخيرة من جلسات الندوة الدولية والملكية الفكرية للملكية الفكرية والتنمية المستدامة، توثيق وتسجيل المعارف التقليدية وأشكال التعبير الثقافي. في هذه الجلسة لدينا محاور تتعلق باستعراض بعض التجارب والتطبيقات العملية في عدد من دول العالم. لدينا في هذه الجلسة 3 متحدثين، وهناك أيضا طلب من متحدث رابع من جمهورية لبنان الشقيقة الدكتور حنا، وهو أحد الحاضرين في منصة الخبراء، وسنحاول أن نعطيها الفرصة الكافية للدكتور حنا اعتزازا أيضا بمشاركته بيننا. المتحدثون اليوم هم الدكتورة جين أندرسون من الولايات المتحدة الأمريكية، ولدينا أيضا السيد جون أولي والدكتورة فوزية إنجلال الدين من جمهورية السودان. السيدة أو الدكتورة جين أندرسون ستتحدث قليلا عن نفسها، ثم ستستعرض التجربة التطبيقية التي عايشتها في الولايات المتحدة الأمريكية. Jane, the floor is yours.
Thank you very much, Mr. Manhari. I want to offer, before I begin, my deep thanks for the invitation to be at this important workshop. I'll just give a brief outline of the work that I've done in this area. I've worked in this area for over 15 years, and I've worked in Australia, Indonesia, the United States and Canada on the protection of traditional knowledge and protection of traditional knowledge communities. I'm currently based at the University of Massachusetts in the United States, where I teach cultural anthropology. I'm also a professor of law at the New York University, where I teach intellectual property and Indigenous rights. I've also spent a long time working with WIPO on the development of certain kinds of international guidelines and policy on the protection and safeguarding of traditional cultures. Some of this I'll talk about in the presentation itself. So it is now very clear how important the recording and documenting of traditional knowledge and traditional cultural expressions are. We are at a stage that requires several stages of action, of which this workshop itself is part. It is important and significant that in the last 10 years, we have moved through what must have been the first stage of this issue, namely the recognition that traditional knowledge and TCEs are valuable and require protecting. While this seems obvious now, it was not always the case. We are all gathered here today because we recognise this issue and want to do something about it. What is not so clear, of course, is what is the best way of proceeding. My perspective, which comes from working for a long time on these issues in local communities in diverse contexts, including Australia, Indonesia, the US and Canada, is that we need multiple strategies that are crafted specifically for the range of different interest groups that convene around this issue. The subject of this workshop is one of the most critical. It does raise complex theoretical questions, as well as addressing practical options that many communities and governments alike are eager to see advanced and developed. On one hand, documentation and recording of TK and TCEs is an easy step. It does not require any international or national legislation necessarily. All one needs is something to document and something to document it with. However, it shouldn't happen in a policy and legislative vacuum. This is what has happened in the past, and it has created some rather substantial problems. There are some rather critical questions of law and ownership of the document itself that arise both at the moment of making and afterwards that require some more considered attention. A policy and legislative framework that supports documentation can help deal with these issues. In the past, as in the present, the person who does the recording has a large say in what is documented. As those who are in this room today recording these proceedings can attest, there is a framework for the general recording to occur at all. But where the camera moves, who it rests on, who it records, is largely a decision made by the person behind the camera. In the past, who was doing the recording was also involved in establishing and creating the value of the record. For instance, some disciplines were more focused on one part of TK and TCEs, and others on another part. This was not only at the expense of other kinds of traditional representations, but this logic also failed to see the interconnections of traditional knowledge. And for example, the connections between TCs and GRs, between the tangible and the intangible. For instance, the anthropologists in Indonesia that were interested in textiles and their represented meaning and design with the patterns themselves, often only these textiles were recorded. Focus was on the knowledge and meaning in the product and in its making. What was not considered was the technical knowledge around the dyes themselves and how these were used within the weaving process, how knowledge about what and where the plant was, how it could be harvested, and what social relationships this harvesting engendered within the community. It really matters that key questions about the objective of the recording are made before documentation begins. Answers to these questions may vary, but they will provide a good base setting the appropriate conditions for the collecting of important knowledge. Documentation of knowledge from specific and unique cultures is a very old pursuit. What is new is the technology that we now have to facilitate better and more comprehensive recordings, and the capacity to reflect upon practices of the past and moderate them, so as to avoid some of the problems that we are struggling to reconcile. In some instances, there is still work to go to convince some states that TK and TCEs are valuable, and valuable beyond a simple economic logic. That is, that TK and TCEs are valuable unto themselves and for what they can tell us about culture, about humanity, and about our ongoing struggle to make sense of the world around us. Once the value of TK and TCEs has been recognised, the next stage of action is to begin the processes of safeguarding this knowledge. I say processes because documentation is one form of safeguarding knowledge. It is not the only one. Documentation only preserves the knowledge in a particular form. It does not, by itself, necessarily support and safeguard the communities from where that knowledge comes. In thoughtful moments, like what we will be hearing from my colleague John Tingoy next to me in the next paper, is that documentation can be a vehicle for supporting communities. But it does not do this automatically, and this is very important to remember. So here we are talking about documentation. Documentation taking many forms, including written documentation, digital and non-digital recording in images and sound. Photographs, video, film, sound recordings are all forms of documentation. There are various ways documentation can be achieved and then collated. Registries are one way of storing documented knowledge, and this is also not a new process. What is before us are important and exciting discussions. It is important not to lose sight of the objectives here and to also keep an eye out for the potential issues that may arise. While there are important overlaps between UNESCO initiatives and WIPO objectives, and Brigitte did an excellent job yesterday of discussing the differences, namely UNESCO objectives work to preserve knowledge, but preserving knowledge is not the same as protecting it, and creating robust frameworks that enhance and inform those modes of protection. There are many parts of this puzzle that need to be worked out, especially working out what it is exactly that law protects and what the consequences of this are. While we are told a story about the relationship between intellectual property law and economics, this is only one part of a rather large story. IP law does not only protect material that is economically valuable, but it also brings material into its orbit that does not have obvious and immediate economic benefits. Copyright law in particular works upon a range of material, sometimes automatically, that has no obvious or immediate economic benefit. In particular, copyright law works on the forms of documentation, regardless of what it is that is being documented. Intellectual property law is also about fostering and nurturing innovative communities and knowledge producers. From its inception, it has had a role in helping certain kinds of communities enhance and develop. What I want to talk to you about today is what rights are generated at the time of documenting, and what this means for the future life of this documentation. I want to talk to you about these issues as they are a critical part of this conversation and need to be upfront and dealt with in the development of any documentation and recording projects. I want to impress upon you all that what decisions are made at the moment of documentation, as well as what happens after documentation, are critical to the success of any documentation project. This is because what happens after documentation can affect who and how this material will be accessed and made meaningful now and into the future. As we all know, we cannot predict what the future holds. Therefore, it is important to lay some parameters and to help those in the future know what our intentions in documenting in the present are. This is where a policy or legislative framework can help guide us. This will help future generations make appropriate decisions about how this documentation should be used and disseminated. There are numerous examples of material that was not considered valuable 20, 30, 50, 100 years ago, but that is now incredibly valuable and incredibly important. But not all this material is available or easily accessible. Some of this material has competing claims for who it is that owns it, who it is that is responsible for the dissemination. No one was thinking about these questions in the past. Even 10 years ago, there was very little thinking about it. And as a professor of a university in the United States that provides training and skills for documenting cultural heritage, these are still issues that researchers themselves are grappling with. So this paper is directed to the questions about who owns this material, but also where does this material go? Who becomes the custodians of it? Who has access to it? When and how will it be available to the public? Are there circumstances where circulation of this material is not appropriate? My purpose is to share with you what kinds of issues need to be considered, what kinds of issues can arise, and how we can best prepare for these. And more importantly, how do we develop better and more comprehensive relationships now in order to prevent conflicts into the future? So a key question, which I'm sure has resonance in Oman, as well as in every other country represented here, is once documentation of TK and TCEs is made, where does it go? Who will be responsible for it now, in 20 years, in 100 years? Historically and contemporarily, documented materials go into archives, libraries, and museums. Archives are document repositories. Registries are a basic archive, and databases are the modern archive. Sometimes this material is kept in archives in the countries where the traditional knowledge comes from. Often it is not. And this is especially the case if the documentation was made by researchers from another country. Much documentation winds up a long way from home, in institutions far from the original locus of the recording. For digital databases and registries, the questions are a little different, as they can potentially be housed anywhere at multiple times. But there also remains real questions here about the security of servers, of mainframes, and really the longevity of the internet itself as an interface for exchanging material. If our digital frameworks were to become unusable for some unforeseen reason in the future, what would happen to all this material? All material is vulnerable, and digital information and documentation techniques have a particular vulnerability also because of their form. Archives, libraries and museums are constantly evolving as new material enters their domain, and they are charged with both safeguarding it for future generations, but also providing ongoing access to it. It hasn't always been an easy task, and in recent years it has become even more difficult, with new publics and new user groups making different demands to the material. Historically, there was very little attention to the source communities from which TCEs and TK was documented. Many thought that these communities would themselves die out, and that such documentation was the last stage in the demise of a community and a culture. Thankfully, this has largely not occurred, partly because culture is a surprisingly adaptable and robust creature that can sustain and indeed embodies change and transformation. But partly because of the presumption of imminent cultural death, those doing the recordings paid very little attention to the subjects of the recordings, to their names, to the authors, to the actual knowledge holders. Many were only interested in the knowledge itself as an extracted and isolated object, something that could be used by others. This kind of documentation has a name. It is called knowledge mining, where raw knowledge is extracted by third parties to be used for other purposes in other places. This material was not recorded for those communities, but for others to use for numerous forms of study and analysis. In almost all cases, it was taken out of the source communities and placed in locations that were impossible to reach. This is regretful and now produces many challenges. It means that many of those same communities now come to the archives and museums looking for access to these collections in order to make new meaning and reinvigorated cultural meaning. We have very important lessons to learn from this history as we embark on the new documentation projects. With the emergence of a new public, these documented communities are requesting access to their cultural material, and a range of new and unanticipated problems have emerged for libraries, archives and museums, namely, who owns this material? As these questions were not worked out at the time of the documentation, these questions are causing all kinds of headaches for institutions worldwide. They are also serving as valuable lessons for what kinds of thinkings need to happen at the time of recording, what kinds of permissions need to be secured, what kinds of agreements or arrangements should be worked out, all of which have profound and long-lasting effects well after the documentation has occurred. The question of who owns the documentation or the recording is rather complicated, or can become complicated because of the diverse interplay of law. At the core, of course, is intellectual property. The most common forms of documentation, photographs, sound recordings, films, written notes and manuscripts, almost automatically enter into an IP network upon their making. Not everything has to be published to secure protection. To the contrary, the act of making itself, for example, a photograph or a sound recording, can vest protection automatically. Not all of these kinds of documentation have the same time periods of protection in themselves or across countries, and this is worth remembering and incorporating into any policy framework. It rather complicates the situation that the subsequent holders of this material, the libraries, museums and archives, are seldom the intellectual property owners either. But as the contemporary custodians, they have a responsibility to manage the material according to relevant and applicable laws. They are thus in the unenviable position of navigating laws, various interests, and various ethical considerations. But dealing with the copyright owners themselves of these documents is one thing. It is quite another dealing with those who have no legal rights. Those communities, those individuals who are the subjects of the recordings, who graciously and generously gave their time and knowledge. In almost every circumstance, these communities had no idea that they were surrendering ownership of the material representation of their TCEs to others. As we heard in the video yesterday afternoon, informed consent is a difficult and important concept at the best of times, and I'm more than happy to talk further about this concept later. But it is pretty clear that you cannot give your consent if neither you nor the person documenting your material knows what will happen to it in the future. Even in the late 1980s, there was no idea how the internet would change the circulation of material. I know many communities that are very troubled by the fact that their special ceremonial material is now accessible by everyone. This ceremonial material that includes songs, motifs, designs, was never designed to be accessed by everyone. Within the community, it has strict rules of circulation. If there was initial consent to make the recordings, and sometimes there was not even that, no one could have anticipated the way that such knowledge can now circulate. No one could have foreseen the internet and its circulatory potential. No one could have anticipated how some kinds of documentation have become more valuable than others through this increased circulation. You cannot give consent for a future that you cannot predict. With the range and extent of problems being experienced across institutions worldwide, and because of the legacies of historical documentation projects, cultural institutions were requesting guidance and help. As a response, and in collaboration with WIPO, my colleague Molly Torson and I co-wrote a set of international guidelines for managing and safeguarding collections of recorded TK and TCEs. This document responds to an urgent need, and there is no current law that deals with the complexity of these issues. I did bring along a copy of this. They're available online on the WIPO website, but I'm more than happy to share that with you after if anyone's interested. I want to stress that these are guidelines to assist archives, museums and libraries in safeguarding and managing their collections, and they are not prescriptive and they are not law. They help in identifying what the legal issues are and what to do when a problem exceeds the law in a particular area. So, for example, the second part of these guidelines goes through very clearly what the intellectual property issues are that any library, archive and museum throughout the world will encounter with their collections of cultural material. These guidelines help people make informed decisions, and this often enables new and equitable relationships between these three parties that have not always been treated equally or fairly. These three parties are the source communities, who usually have no legal rights, the researchers, documenters and recorders, who usually have all the legal rights, and the public, without explicit legal rights, but certainly the constituency who benefits most from the institution's mandate for making their work accessible. These guidelines are certainly not exhaustive. Importantly, we all recognise that there is no one solution because the problems being experienced are quite unique and diverse. For this reason, we included a range of examples of best practices emanating from certain institutions to provide instances of adaptability across institutions. And I'll just give you an example of two of these best practices. The Smithsonian Global Sound Project is an initiative of the Smithsonian Centre for Folklife and Cultural Heritage and was launched in 2005. It aims to make traditional music globally available via the internet. This is one of the recordings that they have in the collection. The collections that the Smithsonian Global Sound Initiative holds include the entire Smithsonian Folkways collection and the holdings of two regional archives, the International Library of African Music in Grahamstown, South Africa, and the Archives of Research Centre for Ethnomusicology in New Delhi, India. With its interactive features, the Smithsonian Global Sound Initiative has been dubbed the ethnographic answer to iTunes. In order to use a recording as opposed to just downloading it, a licensing request form needs to be filled in. The condition, however, is that licenses and permissions are granted on a case-by-case basis and are at the discretion of the Smithsonian Institution. A license fee may be assessed depending upon the nature of the proposed use. The Smithsonian Institution expressly prohibits the copying of any material, text and image files, audio and video clips, on the SGS website except for the purposes of fair use as defined by the United States copyright law. The SGS site notes that royalties go to the artists and the institutions and honour the intellectual property rights of composers, musicians and producers. In other words, the revenue earned from sales of downloads and subscriptions support the creation of new educational content and are shared with archival partners, who in turn pass on a portion of these revenues to artists and communities. The director of the project, Dr. Richard Curran, has stated that there are world music stars who mine the traditional music archive, and the question is, what is the ownership? What is the moral commitment, and how much is going back? When we give them the money, that establishes the intellectual property rights. So far, we have talked a lot about institutions and what happens when material is recorded from their perspective and what kinds of issues need to be reconciled. But finally, let us turn to probably the most important group here, the source communities. As I said at the beginning, documentation is not by itself a means for supporting and safeguarding the communities from which TK and TCEs derive. If these communities do not survive, there will be no more TK and TCEs. And given that these communities are holders of some of the most valuable cultural material, but are the most disenfranchised when it comes to legal ownership and the capacity to assert rights, it is crucial we think about what kinds of strategies we can develop to enhance and support these communities now and into the future. As Brigitte also thoughtfully remarked yesterday, the relationships between documentation and the documented community are probably the most important to consider. This has also been the most ignored historically. We need to change this, and we can change this. One strategy that I've been working on for several years now are the role and function of protocols to safeguard the relationship that communities have to their recorded and documented knowledges. Rather than being written out of the picture, which has been the history, this is a project of keeping communities in the picture and in dialogue with those individuals, institutions, and other third parties who seek to access and use their traditional knowledge. Protocols are one of the most interesting modern developments in intellectual property law and policy. This is because they are increasingly being used as alternative means for managing access and control of knowledge in contexts where the limits of intellectual property law have been reached. For Indigenous and marginalised communities who have been subject to the extensive knowledge exploration and expropriation endeavours of others, protocols have come to offer themselves as practical strategies that protect and respect local knowledge resources, whilst simultaneously addressing the social and cultural frameworks that enabled the exploitation of these resources without appropriate acknowledgement, consent, or respect to begin with. Protocols offer the capacity for both renegotiating unequal knowledge-sharing practices, as well as establishing new relationships between custodians of valuable cultural resources and the multiple external users of these same resources. So what are protocols?